Hello students, welcome to Ashish Pulala classes. Today in the present video of CPC, I am going to discuss with you very important provision of CPC which deals with the place of institution of suit where the local limit of jurisdiction of the courts are uncertain. Sometimes it becomes very difficult to say with certainty. While instituting a civil suit in relation to any immovable property, that the particular immovable property for which the civil suit is going to be instituted situate within the jurisdiction of which court. Because many times it has been seen that the immovable property is situated within the territorial limits of two or more courts. But the plaintiff is not sure which of the several court has got a jurisdiction over such immovable property. So, what should be done in that case? Such type of cases are dealt with by section number 18 of CPC. Section number 18 of CPC is divided in two subsections. According to subsection 1 of section number 18 of CPC, where it is alleged by the plaintiff in his plaint that he is uncertain within the local limit of the jurisdiction of which two or more courts any immovable property is situated, then any of those courts for which he has got uncertainty may, if he has filed the civil suit in that court, if that court is satisfied that plaintiff is speaking true, and if the court is satisfied that there is actually a ground for alleged uncertainty, the court is satisfied that there is a confusion in relation to the jurisdiction of that court. That court shall record a reason to that effect why there is a ground for alleged uncertainty, and after recording a statement to that effect, the court shall proceed to entertain and dispose of any suit relating to that immovable property. Okay. But after recording a statement to that effect, there is a ground for alleged uncertainty. What will be the validity of the decree passed by such court? If the court will pass any decree in such type of cases, that decree in the suit shall have the same effect as if the immovable property were situating within the local limits of its jurisdiction. However, the most important point which is to be considered in mind by the plaintiff, that the court in which the said suit be instituted must enjoy pecuniary as well as subject matter jurisdiction of the court. If that court has not pecuniary or subject matter jurisdiction, then that court cannot try and entertain the suit. This type of problem arises when boundaries of the state are either destroyed or altered due to certain action, and it is a great confusion that where to file a civil suit. That means to say, this provision intend to avoid difficulties regarding jurisdiction that may arise where boundaries of the state are either destroyed or altered due to certain actions. Sometimes it has been seen by Calcutta High Court that when there is absence of notification as to the boundaries of a district, then that absence of notification as to the boundaries was held to create a reasonable uncertainty, and court can exercise its jurisdiction by adopting section number 18 of CPC. Okay, so this was something about subsection 1 of section number 18. Now let us see what is stated in subsection 2 of section 18. According to subsection 2 of section number 18, where a statement as to uncertainty of jurisdiction is not recorded, where the court has not recorded that whether there was uncertainty of jurisdiction or not, even then the court proceed with the suit and a decree is passed. Then what will be the validity of that decree? where a statement as to uncertainty of jurisdiction is not recorded and a decree is passed, and thereafter, in appeal or in revision, if such a decree is challenged only on the ground that it was passed without jurisdiction, then what the appellate or revisional court will do? Then the appellate or revisional court shall not allow the objection, for the reason that why you have not taken the objection before the lower court when the suit was presented or when you have appeared before the court. Okay, but there is also one more provision which has been made in subsection 2 of section number 18, where the appellate or revisional court is satisfied that there was no reasonable ground as to the uncertain jurisdiction of the court, and by passing the decree by the court there is a failure of justice with the defendant, then it may allow the objection as to the jurisdiction and can set aside the decree as well. Okay, so it is very important to note here that the objection as to the jurisdiction must be taken in the court of first instance if you want to be, where the plaintiff comes with a plea of uncertain jurisdiction before the court. Okay, court has taken a plea that the plaintiff has taken a plea of uncertain jurisdiction. Then the defendant must raise his objection, if any, before the court of first instance, and this objection should be filed at the first available opportunity, not at the time of arguments. But if the defendant fails to do so, he has not taken any objection at the first available opportunity, and subsequently he takes such objection at the stage of appeal or revision, then the appellate or revisional court shall not allow this type of objection unless, in the opinion of the appellate or revisional court, they are satisfied that there had been a failure of justice. So this is something about section number 18 of CPC. If you want to get notes of this lecture, then notes of this lecture are available in the description. So kindly subscribe my channel and follow the links. Thank you very much.